the 10 common mistakes people make with existing trusts. All right. So I left off with mistake number 5. The powers of attorney are outdated. Now, what the heck am I talking about? So remember, part of a comprehensive estate plan is your financials powers of attorney and your medical powers of attorney. Now, the financial goes by the correct term, advanced directive, but I'm just going to keep it simple and call it financial POA and medical POA. Once again, when you create the financial POA and the medical POA, you name an agent. That agent or agents, and I'm just going to use it, make it simple, make it one agent. That agent is the one responsible to fulfill your wishes. So let's use the medical side. They are the ones, again, that are, quote, officially in charge of all of the decisions that you have made in your living trust. I want to be on life support. I don't. I want to have hydration. I want to have food. I don't. All these different things. This is what the agent of the medical POA. Once again, common mistake is people name somebody, or they named them years ago. That person may not be around. Do you really want someone to be your your medical POA if they live in Topeka, Kansas, and you're here in Reno? Probably not. So think about, once again, location. Are they here locally? Can they run to the hospital in the event that you become unable to make your own medical decisions? So very important on the medical POA. Same thing on the financial side. Not quite as important as the medical, but same thing. You're going to name an agent or agents to handle all of your financial affairs. They would deal with companies like mine, on the investment side. They would deal with attorneys and CPAs and real estate agents and so on and so forth. So once again, they need to have a good financial acumen, be able to understand things, talk to people, be organized, so on and so forth. But who have you named on that? Is it somebody here locally? Not as critical, as I said, as the medical, but at least they should understand technology where they could jump on a video call with the professionals and talk with them. Very important. Is it the right person? Can they handle it? Maybe when you named them 10 years ago, as an example, maybe your estate was hopefully it was, significantly smaller then than where it is now. Is the person you have as your financial POA, can they handle an estate the size of yours? Right? That's another major consideration. So, question you want to ask, would the people you've chosen then, when you wrote the trust, would they still be your choice? If the answer is no, time to have a restatement. Number 6, your family situation has changed. Boy, marriage, divorce, births, deaths, grandchildren, special needs children, children that you thought were going to be great and they developed a drug or alcohol problem, or you're trying to shield their inheritance from a sticky finger wife or ex-wife or ex-husband, so on and so forth. Very, very important to understand the family dynamics and family situation. There are ways, again, in the estate planning documents to protect, again, your money going to, let's say, your son who's got a sticky finger wife, or your daughter who has a sticky finger husband. There's a way to protect it so that those daughter or son-in-law can't get their hand on it. But it has to be the right documentation in the living trust. So does your trust that you wrote X number of years ago still reflect your wishes?